Hello and welcome back to another episode of Quotes This Week, your go-to source for the latest legal updates presented by livelaw. I'm your host, Syed Amir Hussain, and I'm here to take you through the most significant updates from the week. From the corridors of the Supreme Court to local judicial proceedings, I'll be providing you with clear and concise summaries that keep you informed and ahead of the curve. Remember, for a more in-depth understanding, do visit our website at www.livelaw.in. In today's episode, we cover Bulldozer actions in Somnath, the striking down of UP's Madarsa Act, ANI versus Wikipedia, removing the word secular from the preamble, and much more. So let's dive into the headlines. In one of this week's major updates, a bench of Justice Sanjeev Khanna and Justice Sanjay Kumar of the Supreme Court on 21st October heard a petition filed to challenge inclusion of the words socialist and secular in the preamble to the Constitution by the 42nd Amendment. The petition has been filed by Balram Singh, senior BJP leader Dr. Subramanian Swamy and advocate Ashwini Upadhyaya. They argue that the preamble was a declaration made on 26 November 1949 and adding new words to it through later amendments is arbitrary. They claim it is incorrect to suggest that as per the current preamble, the people of India on that date in 1949 agreed to make the country a socialist and secular republic. The petitioners also stated that if this kind of amendment is accepted, it would set a precedent for future amendments to remove words like democratic from the preamble. Justice Khanna explained that the words added by the 1976 amendment were clearly marked by brackets, making it obvious that they were introduced later. He also highlighted that terms like unity and integrity of the nation were amongst the additions made through this amendment. Justice Khanna further said that several judgments have affirmed that secularism has always been part of the basic structure of our constitution. Ultimately, the matter was listed for hearing in the week commencing on 18th November. In the next big update coming this week, the Supreme Court on October 22nd reserved judgment on a batch of petitions filed against the judgment of the Allahabad High Court, striking down the Uttar Pradesh Board of Madarsa Education Act 2004 as unconstitutional. Before the High Court, a writ petition was filed challenging the authority of the UP Madarsa Board as well as objecting to the management of Madarsa by Minority Welfare Department and other connected issues. A bench comprising CJI D.Y. Chandrachud, Justice J.B. Pardewala and Justice Manoj Misra, which started hearing the matter on 21st October, completed the hearing on 22nd. CJI pointed out that the Act gives rule-making powers to the state to lay down standards. When the CJI pointed out that there are other similar religious institutions which children join at a very young age, senior advocate Madhavi Diwan replied that those are instances of people taking monastic vows to renounce the world and cannot be compared to madarsas, where the students are not seeking to renounce the world but to live there. The bench also heard senior advocates A.M. Singhvi, P. Chidambaram, Salman Khurshid and M.R. Shamshad in brief rejoinder submissions on behalf of the petitioners. Singhvi said that the striking down of the act amounts to a virtual ban of the madarsas. If there are deficiencies in the standards, the state should exercise its powers under the act to improve them instead of dismantling the whole structure. He added that all modern subjects are taught in madarsas. Chidambaram suggested that the service conditions of the teachers in madarsas be made the same as other teachers. Also, the state of Uttar Pradesh, which has chosen to not challenge the High Court's judgment, took the stand that it was wrong to strike down the entire act and only the violative provisions needed to be nullified. The judgment is now reserved. Stay tuned to LiveLaw to know the verdict. This week, a 9-judge constitution bench of the Supreme Court on 23rd October by an 8:1 majority has held that states have the power to regulate denatured spirit or industrial alcohol. The 9-judge constitution bench comprising CJI D.Y. Chandrachud, Justice Rishikesh Roy, Justice Abhay S. Oak, Justice B.V. Nagaratna, Justice J.B. Pardewala, Justice Manoj Misra, Justice Ujjal Bhuyan, Justice Satish Chandra Sharma and Justice Augustine George Massey. The court was essentially tasked to examine whether the Industries Development and Regulation Act give complete authority power to the union on the subject of industrial alcohol. The majority has held that the term intoxicating liquor in entry 8 of the state list of the 7th schedule will include industrial alcohol. It said that the term intoxicating liquor cannot be interpreted narrowly to include only alcohol which is fit for human consumption. Liquids which contain alcohol which can be used or misused for human consumption can be included within this term. CJI Chandrachud, who wrote the judgment for the majority, stated the term intoxicating can also be understood as poisonous. Justice Nagaratna, in her dissent, held that industrial alcohol means alcohol which is not fit for human consumption. An artificial interpretation cannot be adopted to give a different meaning to the term intoxicating liquor, which is contrary to the intention of the framers of the Constitution. According to Justice Nagaratna, just because industrial alcohol can be diverted and misused for human consumption, the meaning of entry 8 list 2 cannot be stretched. To read the full judgment, visit www.livelaw.in. Coming to an update on the Delhi Ridge illegal tree felling matter, the Supreme Court on 24th October observed that there was a discrepancy between the statements of the chairperson of the Delhi Development Authority, that is the LG, and the vice chairperson of the DDA regarding the date on which the LG was informed about the illegal felling of the trees in the Delhi's Ridge forest. A bench comprising CJI Chandrachud and Justice J.B. Pardiwala and Justice Manoj Misra was hearing the contempt case initiated against the DDA Vice Chairman for the felling of the trees in Delhi's Ridge without obtaining the mandatory permission from the Supreme Court. On September 16th, the court had asked the chairperson to file a personal affidavit on various aspects. The court noted that as per the affidavit filed by him, the information about the illegal tree felling was conveyed to him on June 10th by the vice chairperson. However, as per another letter issued by the VC, the information about the tree felling was conveyed to the LG on April 12th. Taking note of this mismatch, the court asked both the parties, the Delhi LG and then the DDA VC Shubhashish Panda, to file affidavits on this discrepancy. The matter will be next heard on November 5th. In another important news coming this week, a bench of Justice B.R. Gavai and Justice K.V. Vishwanathan on October 25th heard a petition filed by Somnath Patni Muslim Jamaat, a trust representing the Patni Muslim community of Prabhas Patan, regarding demolitions of structures carried out by the authorities in Somnath recently. The petition challenges Gujarat High Court's order on 3rd October, which refused to order a status quo on the demolitions of Muslim religious structures and homes in Gujarat's Somnath. Senior advocates Kapil Sibbal and Huzaifa Ahmadi, appearing for the petitioners, said that though the structures are on public lands, they are protected monuments, registered waqfs and public trusts. Sibbal alleged that the authorities were selectively proceeding against one set of monuments while excluding temples situated on public lands. He alleged that the present attempt is to allot these lands to third parties. But Solicitor General Tushar Mehta, on behalf of the state of Gujarat, undertook before the court that the lands would remain with the government and not be allotted to any third parties till the next date of hearing of the matter before the court. After hearing arguments, the bench comprising Justice B.R. Gavai and Justice K.V. Vishwanathan posted the petition on 11th November. On this day, the contempt petition filed by Somnath Patni Muslim Jamaat, alleging that the Somnath demolitions were carried out in violation of the Supreme Court's order, is also listed. In the next update, the Supreme Court on 24th October issued notice on a petition challenging the Kerala High Court's order in the matter concerning Justice Hema Committee report. The High Court had directed the police to register FIRs on statements made by women actors to the Justice Hema Committee regarding the abuses faced by them in the Malayalam cinema industry. The High Court, after reading the entire report, had stated that the statements revealed commission of cognizable offences and directed the Special Investigation Team to register FIRs after conducting preliminary inquiry. An SLP was filed by film producer Sajimon Parail, challenging this direction of the High Court. The SLP contends that when the victims themselves were disinclined to lodge FIRs, the High Court could not have issued such a blanket direction. The statements made by the victims to the committee 6 years ago cannot be regarded as information as per Bharatiya Nagrik Suraksha Sanhita when they themselves are disinclined to initiate criminal proceedings and have not asserted the statements later. The SLP further states that the SIT itself has stated before the High Court that none of the witnesses who gave statements before the committee were ready to cooperate and give a statement to the police. The bench of Justices Vikram Nath and P.B. Varale issued notice and posted the matter to 19th of November. On 1st September, a new emblem and the flag of the Supreme Court were unveiled by the President of India to commemorate the 75th year of the Supreme Court. The statue of Lady Justice, which is placed inside the judge's library, also had certain changes. Traditionally, the statue wore a blindfold to signify that justice would be administered impartially without regard to the status of the person. The new statue of Lady Justice is not blindfolded and carries the book of the Constitution of India instead of a sword. In regard of these changes, the Executive Committee of the Supreme Court Bar Council has passed a resolution objecting to the unilateral changes made to the emblem and the statue of Lady Justice without consulting the members of the bar. The association has also objected to the proposal to build a museum in the former judge's library. It had earlier demanded a library and a cafe-cum-lounge for the members of the bar. The resolutions that bar members are equal stakeholder in the administration of justice, but these changes, when proposed, were never brought to their attention. We are totally clueless on the rationale behind these changes, the resolution read. This week, a bench comprising Justice Bela M. Trivedi and Justice Satish Chandra Sharma of the Supreme Court on 25th October heard a writ petition filed by student activist Sharjeel Imam for expeditious disposal of his bail petition in Delhi riots conspiracy case, which has been pending since April 2022. Imam was booked under UAPA and IPC over allegations of conspiracy behind the 2020 communal riots that took place in northeast Delhi, following protests against the Citizenship Amendment Act. Reportedly, these riots left 53 people dead and about 700 injured. At the outset, the bench asked why the petitioner had filed the writ petition in the Supreme Court when the matter was pending in the High Court. Imam's counsel, Senior Advocate Siddharth Dave, submitted that he was not pressing the plea for bail before the Supreme Court and was only praying for the hearing to be expedited. Imam's appeal challenging the rejection of bail was filed on April 2022 and it was adjourned 64 times, with the petitioner seeking time on 8 postings. The bench noted that the matter was listed before the High Court on November 25th. The court refused to entertain the petition but gave him the liberty to request the High Court to seek expeditious hearing. This week, the Kerala High Court has refused to intervene in the conviction of a husband who was found guilty of criminal breach of trust under Section 406 of the Indian Penal Code for pledging his wife's gold without her consent. Criminal breach of trust happens when someone is trusted with property or money and uses it dishonestly. It means breaking the trust by using it for personal gain or in a way not agreed upon. If found guilty, the person can face jail time up to 3 years, a fine, or both. The prosecution case is that the mother of the wife gifted her daughter 50 sovereigns of gold ornaments during her marriage. The wife entrusted this gold to her husband, asking him to keep the same in a bank locker. But then he, without his wife's knowledge, pledged the gold to a financial company. The trial court convicted him and sentenced him to undergo simple imprisonment for 6 months. When the case came before the Sessions Court by way of appeal, the court, in addition to the 6 months simple imprisonment, directed the accused to pay compensation of Rs 5 lakhs to his wife. The accused challenged this finding, saying that the offence is not made out from the evidence. Single bench of Justice A. Badruddin held that all the elements of the offence are made out, that the husband was entrusted with the gold, which he dishonestly misappropriated and converted it to his own use, violating the trust of his wife and causing her loss. Thus, the order of conviction was upheld. Hello. The Apex Court this week permitted a candidate suffering from muscular dystrophy to participate in the ongoing counselling for the NEET-UG 2024, considering that the expert report opined that he could pursue the MBBS course with the help of assistive devices. The bench, led by CJI Chandrachud, was hearing a plea filed by a candidate facing 88% muscular dystrophy and was disqualified from pursuing MBBS on the ground that the NMC guidelines require bringing down the disability to less than 80% for those with this condition to pursue MBBS. In muscular dystrophy, the individual's body muscles are progressively weakened and face a breakdown, making it difficult to carry out normal physical activities. Since the petitioner's disability could not be brought down to less than 80%, the Bombay High Court had refused to grant any relief. On the previous hearing, the top court had requested expert doctor to assist the court. As per the report, the petitioner could pursue the course with the help of assistive devices. The court noted that the petitioner had successfully scored 601 out of 720 marks in the NEET-UG 2024 exam despite the obstacles of his disability, allowing him to appear for the counselling. The bench, however, clarified that the present order shall not be treated as a precedent for future issues of law that may arise. A division bench of the Delhi High Court comprising Chief Justice Manmohan and Justice Tushar Rao Gadela on 21st October heard the ongoing defamation battle between Wikipedia and Asian News International. ANI had filed a defamation suit against Wikipedia for allegedly defamatory content on its page, accusing Wikipedia of harming its reputation. A single bench of Justice Naveen Chawla, who is hearing the matter, had previously ordered Wikipedia to provide details of 3 individuals who edited the page, but ANI claims Wikipedia failed to comply. During the hearing, the court said that being labelled as a puppet of an intelligence agency or a government stooge is the worst thing that can happen to a news agency. The court expressed concern that the ANI would have no defence if it is called a stooge of an intelligence agency. The bench made it clear that the news platform ANI must have a remedy and defence in court, especially when such severe accusations are made. Acknowledging the Wikipedia's valuable role as an open source encyclopedia, the court warned that it is vulnerable to manipulation. Further referring to the page on Wikipedia that was based on the proceedings before the single judge, the Chief Justice stated that the page inaccurately suggested the court had threatened to shut down Wikipedia, that the court was intervening to solve the issue and it was not right to make contemptuous remarks against it. When it was informed that Wikipedia had taken down the page on the pending defamation proceedings, the fresh contempt plea moved by ANI against Wikipedia for failing to comply with the takedown order in time was then closed. The bench has now directed the parties to file their responses and listed the appeal for hearing on October 28th. And that's a wrap for this week's Legal News Roundup. Before we bid adieu, the entire LiveLaw team has a small request for our dedicated viewers. As an independent and fact-driven media organization, we are deeply committed to fearless and ethical journalism. To continue bringing you the latest legal updates, especially in this dynamic audio-visual format, we rely on your support. Here's how you can help. Give our video a thumbs up if you found it informative. Share it with your family, friends, classmates, and colleagues. Make sure you're subscribed to our YouTube channel for more insightful content. Drop your valuable thoughts and feedback in the comments section below and hit that bell icons to stay updated with our latest releases. Don't forget to visit our website at www.livelaw.in for in-depth reports and analysis. Not only this, but the LiveLaw channel offers membership for only ₹89 per month. Become a part of LL supporters today to access exclusive perks such as loyalty badges next to your name in the comments and live chat, priority reply to comments, and for our student pass audience, early access to explainers and legal updates. I'm your host Syed Amir Hussain and it's been a pleasure bringing you this week's Legal News Roundup. Until next time, stay informed, stay engaged and stay tuned to LiveLaw. Thank you for watching.